And to unpack further details on the judgment, which will be announced by the Constitutional Court with regards to the secret ballot, is a constitutional law expert, Mr. Marinus Wiechers, joining us live from Pretoria. A very good morning to you, sir. Thank you so much for joining us right here on 8 and 7 this morning. Well, we are expecting the judgment to be announced by the Constitutional Court this morning regarding the secret ballot, which was required by the United Democratic Movement and other opposition parties. Talk us through expectations of what is expected to transpire this morning at the court.
Yes, I'm sure there are many people and many persons, even in Parliament, members of the governing party, who should like to have a secret ballot, you know, given the very serious allegations and aspersions and things being said against the President. And in fact, the Constitution makes provision for a secret ballot in the case of election of a president, not specifically in the case of a motion of confidence, but the Speaker has the constitutional right to say, okay, let's have a secret ballot in this case. However, it's very doubtful that the Constitutional Court will step in and dictate to Parliament how they should run their own business, because the Con Court is a protector of the Constitution. It looks at the lawfulness of acts, certain executive acts, and say, for instance, the governing party restricts or violates the freedom of speech in Parliament. Yes, then the Constitutional Court can come in and correct that and monitor and protect the constitutional rights of members of Parliament. But in this case, for this application, the court is asked to step into Parliament and take part in parliamentary proceedings, and the court can't do that. The court can't become part of the legislator and conduct and dictate the legislative process. You see, that would be against the separation of powers. Now, the separation of powers is a doctrine. It's executive, it has the Parliament on the one side, and on the other side, the courts. Now, if you don't adhere to that basic principle of a constitutional law, then you put the courts in a position to govern. And on the other hand, that would lead to the extreme difficulty that the Parliament then encroaches on the independence of the courts. So the doctrine of the separation of powers is vital to keep the constellation of our constitutional edifice in place. And I'm very doubtful that the Constitutional Court will step in and dictate to Parliament to have a secret ballot.
And now, Mr. Wiechers, the United Democratic Movement has actually cited Section 102 of the Constitution for the reason of their plea. Is there actually a section in the Constitution that permits a secret ballot? Just talk us through the legality surrounding that.
Yes, as I mentioned, there is a possibility of a secret ballot in the case of the election of the President. So the Speaker would be quite acting Constitution to say, well, there is in the Constitution a possibility of a secret vote, and in this case, in the case of a motion of non-confidence, although it is not stated clearly or explicitly, because of the Constitution acknowledges a secret ballot procedure, then I'm going to ask for a secret ballot in this case. But as I've said, it is very doubtful whether the Speaker will do that, given the outright stance of the governing party in this matter. And as I always also said, it is impossible for the court to step in and dictate the internal workings and procedures of Parliament.
And now, the absence of a secret ballot, would it actually undermine the entire purpose of the no confidence motion, which is requested by the opposition parties?
Sorry, I didn't hear that. I didn't catch that.
Repeat that for you. The absence of a secret ballot, should there be the absence of the secret ballot, would it actually undermine the entire purpose of the no confidence motion set against the president by the opposition parties?
No, not really. Not really. Yes, you're right in the sense that it wouldn't succeed. But then the publicity around this whole matter makes it very, very, very important. And what is important, you can say, well, the whole court application was futile, but it's not, because the court will now be asked to tell us very clearly what the doctrine of separation of powers mean. And that is a question that crops up each and every time. It's also cropped up in the sense, remember, when the president changed his members of his cabinet. And there again, there's a question, is it against the principle or the doctrine of the separation of powers to interfere with this prerogative of the president? So the court decision will be utmost important to understand this basic foundation of our Constitution. And I don't think for one moment it's been a futile application.
And now lastly, before I let you go, sir, just talk us through with regards to the consequences of not actually having a secret ballot and the risk this might actually bring.
Yes, if it's not a secret ballot, it will all depend how the governing party instructs its members how to vote. And if the party says, no, look, you're members of the party, we decided against the secret vote, and the members would be almost compelled to follow the direction of the party. If they don't, we have a party system, and it's a very strong system, and it's still not a bad system. But if the parties decided, the governing party, not to have a ballot vote, it would be very, very difficult, almost impossible for members of the party to vote against the, or vote in favour of the motion of the non-confidence.
Well, Mr. Marinus, thank you so much for your time and for your opinion on that matter.